You won't believe how many employers knowingly or negligently break labor laws in this country. I mean, lawyers sue companies every other day for wrongful termination, discrimination matters, and retaliation. And lawyers will never run out of work because employers simply just can't stop breaking labor laws, either with impunity or negligence. Here are the most common labor law violations that I see across all companies, no matter the size. Mistake number 1, firing someone without a disciplinary hearing. You can't just call someone or summon your employee to your office and say you're fired. Kenyan law says if you're accused of misconduct, if you accuse an employee of having done some sort of misconduct, they have a right or they need a chance to defend themselves, regardless of the nature of the particular misconduct or offense. They have a right to defend themselves in a proper disciplinary hearing. If an employer does not conduct a disciplinary hearing that is well constituted and is procedurally fair, then there just might be a potential claim for unfair termination. Mistake 2, employers failing to issue a show cause letter. Before an employer considers terminating an employee's employment, an employer ought to issue a letter to the employee explaining to him or her the alleged misconduct that they are considering terminating him or her based on. This letter outlining these alleged offenses or misconduct is what we call a show cause letter. Without it, any termination becomes shaky and possibly illegal and unlawful. Mistake number 3, an employer changing someone's role or pay without consultation and written notice. You can't just wake up one day or act on your whims and decide to change an employee's role, especially if it's a demotion or a major shift, without first discussing this with the employee and if they're in agreement, giving them a formal written notice of these changes. Kenyan law requires that any major changes to job duties, pay, or even the work location to be communicated in writing and to be done with the employee's input. Doing it suddenly without mutual agreement can amount to constructive dismissal if the employee later resigns and signs these unilateral changes as the reason for the resignation. Mistake number 4, ignoring employee complaints. If an employee raises a harassment, safety, or even a pay concern, and HR or management goes quiet or silent about it, that silence can later be used in an employment court to try and justify that the workplace was toxic when an employee later resigns. And toxic workplaces, those ones attract constructive dismissal claims. Mistake number 5 that I also see a lot is employers issuing termination letters or notices which do not match the reasons that were indicated in the show cause letter. For instance, HR can give a show cause letter citing absenteeism as the possible reason for considering terminating an employee's contract. But you find that the final termination letter includes or provides or cites that poor performance is the reason for termination. That inconsistency can destroy the company's legal defense because you have brought up a totally new reason why you're terminating, that the employee was not given an adequate chance to defend themselves. Remember, the show cause said absenteeism. The employee defended themselves on absenteeism. So if you bring about a new issue altogether, poor performance, then you have not given an employee a chance to defend themselves on this alleged poor performance. So that termination letter will just cause you legal problems in an employment court. The reason for termination indicated in the termination letter must match the reason why you confronted the employee in the first place or the accusation initially leveled against the employee in the show cause letter. If it doesn't, then the process looks unfair, and that is how employers lose cases. Mistake number 6, employers really like to misuse or even misinterpret this term summary dismissal. Even if an employee seriously messes up, they still deserve due process. Under Kenyan employment laws, summary dismissal must be justified, it must be evidenced, and it must be procedurally fair. It doesn't matter how big of an offense you think the employee has committed warranting what employers loosely term as summary dismissal, which warrant on the spot termination according to employers or some employers. You can't just yell gross misconduct or say gross misconduct loosely in a letter and fire them on the spot. Courts don't allow such shortcut justice. Mistake number 7, some employers like withholding or delaying an employee's final dues. Some employers like to hold on an employee's last salary or other final dues, hoping that they'll give up or ultimately let it go, and they keep that money or those dues to themselves. That delay alone can get an employer sued. Calculate well and pay them promptly. If there's a dispute about this whole issue of final dues, document it properly. Mistake number 8, Some employers never keep written records or paper trails. Remember, the burden of proof is always on the employer to prove most of the processes involved in termination. You find that there are no contracts, there are no warning notices, there are no email trails, there are no meeting minutes, and this means the HR file is incomplete to justify the termination that was done. In court, if it's not on paper, it might as well not exist. That's how employees win, by simply showing that the employer has no documentation or written records. You don't want to find yourself in a situation as an employer where it's your word against the employee's word. You will definitely lose that battle or that case. So one wrong move by the employer can cost the company up to 12 months' salary in damages payable to the employee if the court finds that the termination was not procedurally done. The law permits or can award an employee up to a maximum of 12 months of their pay as damages for having conducted a shambolic unlawful termination exercise. And if you're an employee and any of these things that I've just discussed in this video sounds familiar, then you might just have a case. Remember, as an employee, you have up to 3 years to file an employment claim. So these 3 years start counting from the date when you deemed that you unlawfully or unfairly terminated. So don't sleep on your rights.